People against Saracen, Charles Christian Saracen, 25R514011, 25R514237, 25R514180. And I have another file. I'm sorry, 25R514011.
He's the sit, Your Honor.
That's fine. 25R514237, 25R514001, and then I also have 25R514180. Your name, sir?
Charles.
You have an anti-blight charge and an operable motor vehicle. This citation was issued September 2nd. And then you owe money on 3 other cases, according to our records, $198, $165, and $198 respectively. So on 011, $198, 237, $165, and on 001, $198, you have the right to a lawyer. Would you like an attorney? Okay. You can go out in the hallway and we'll set you up with an attorney, and then you'll speak with him or her, and either way you're coming back in here, okay? Thomas Stephen Chapman, 25B1 49246 A and B. Morning, Mr. Baldwin. What case do you have here?
Nolan.
Your name, sir? You're charged with moving violation, causing serious impairment, causing a broken nose, and then you also have, that's on file A, and then you also have disobeyed traffic signal. You have the right to a lawyer on these, like a lawyer. It's up to you. I can't answer that for you. You didn't go to law school, right? Something like this, I would get one. We'll set you up with a lawyer. Go have a seat out in the hallway, and he will set you up. People against Marcus Talafaro, Lovett, Fuller, 24B146740A.
Thank you, Your Honor, and good morning. For the record, House of Counsel, Attorney Mike Baldwin, on behalf of Mr. Fuller, sir, please state publicly. Thanks, Judge. We're back today on this sentencing on
Put
about.
Beth in here. I need Beth. Okay.
I believe there were 2 considerations that the court wanted to emphasize. Completion. One of them is he was to test. He did. He's compliant. Number 2. He had the OWI, and Your Honor wanted him to clear that warrant. He has other outstanding warrants, and he's working through those. He's due to.
All right. Let me just get the probation director over here, but I want to just summarize here. He was here on September 4th.
Correct.
There was a charge of failure to submit to twice monthly testing as ordered on August the 5th.
Correct.
And failure to clear all warrants. Those were the 2 charges, correct?
Yes. And then of particular interest to Your Honor was the OWI that you know, addressed immediately and did do that. And he also tested, and he was reportedly he was.
All right. And he pled guilty to these 2 charges, or at least was found guilty. I don't remember if it was a plea or a finding. And then I told him to test that day. Ms. Reynolds, your name? Can't read my own writing. Where did I order him? On site, right?
Yes.
And then I set a sentencing for this morning at 8:45, and I said he was going to, it said, or at least my notes say, it appears he's going to 34th on September 15th. Did he do that?
Yes, I did.
What happened on that?
They set another court date for October 16th.
All right. Was his test negative?
His test was negative and he went as well.
And what's your next court date, sir?
October 16th.
Moreover, Your Honor, you may remember he was paying an inflated rate of apartment rent. He lost that apartment, so now he has more money, and his objective is to funnel that in these warrants, predominantly at the 36th district. He's due to discharge in March of next year, so he has a plan to have all of these warrants clear.
What was the offense date on the drunk driving out of the 34th? Can you tell me?
Yes, Your Honor, on March 27th, 2023.
All right, but he was not on probation at that time here. What do you think?
He's compliant with everything else. He's very active and engaged in treatment. Mr. Fuller, from the beginning of probation really has turned it around as far as he does communicate with me. He went for this test. Counsel's correct. It was negative at on-site. I think the issue is he's dragging the feet, and that might be financially motivated as far as clearing up the warrants. He has 9 total outstanding warrants, and now this pending pre-trial in Romulus on October 16th. So that's where we're at, but all the other terms and conditions he's compliant with. His SoberLink work program is completed. Everything else, VIP, again, has been very spot on.
I just want to check out the warrants. It looks like most of them, at least.
I did print it this morning in preparation, Your Honor. I do have those highlighted if you want to see my printout.
No, that's okay. They're mostly for civil infractions, it appears, other than that one, correct?
The big concern was 34.
Right. All right. Any recommendation or anything you've...
At this point, Your Honor, I think a new date to clear those warrants. It sounds like, according to counsel, that Mr. Fuller sounds like he probably has a plan. He's in a financially better spot as far as hopefully being able to take care of this stuff.
You realize you got violations, right? I mean, a lot of those happen on one show cause. But I remember you. I'm never going to forget you. I'm telling you.
Yeah.
Some of the nonsense he pulled in the beginning.
What it appears his pattern of behavior is he'll get himself in a situation, he lets it just kind of linger, and then he picks it up, and then he starts moving with it. And that seems to be a pattern. So I think he's on track, and he's moving through the probationary process. He has a plan. As you may recall, he has a very good job. I believe that's with Ford. So he is gainfully employed. He is stabilized. He has residency. So I'm going to ask the court to allow him to continue on probation, allow him to continue doing the things that he needs to be taken care of so he can take care of his business.
Anything else you want to say, sir? I'm just going to tell you that I need another page of a register just to staple it on there. The problem I'm having. Yeah, I'm having a hard time forgetting what you did in the beginning. I mean, just total distrust I have right now. You said, maybe you're getting better. Maybe that was a wake-up call. You're to pay additional costs of $75. You're to serve 1 day on the court work program and pay $35 for that. You're to serve 4 hours of community service by October 20. You are to clear all of your warrants by October 31, Mr. Fuller. I expect them all cleared by then. Do we understand one another?
Yes, sir.
Okay. So he owes 110 on this, and we'll set you up on the court work program. But go ahead. Was there something else?
You just need to clear or getting the matter resolved to fruition with the court. It's not what you're always looking for. The system will move at its pace. He just wants you to clear the warrants.
He's going to have to pay those civil infractions.
Yeah.
Is the problem.
To clear the warrants.
All right. Can you pay the 110 now, or do you need 10?
I'll be fine.
Pay by, I'll just say, how much time? Can I just say by October 1?
It's fine.
By October 1. Okay. Thank you.
guys.
Thank you.
Hey, guys.
You need to see him?
Juan Alexander Ortiz. Do we have Mr. Carmen on this case, or
So,
this is 25B148377?
Michael A. Carmen, 37384, without the defendant.
Let's go for it.
Do I have a Jacqueline Alea on here? Do I have any employee of Brownstown Forest View or anybody from Brownstown Forest View? Sir, your name?
Alexander Ortiz.
Mr. Kerman, your client pled guilty previously under section 771.1 to telephone harassment. He was referred for a screening and for a pre-sentence report. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
Your Honor, I have. There are not at this time, but just something I want to emphasize that currently Mr. Ortiz is a stay-at-home father, has 5 young children, all of whom are in school. He's doing some side construction jobs, but he's got his hand full with his children. Otherwise, factually accurate and would ask for to adopt the recommendations of probation.
I just want to make sure that Jacqueline Alayon is not here, Lisa. She's not here.
No, not on Zoom.
All right. Sir, is there anything that you would like to say?
Apologize to the court and my family.
Do you think any of these actions were appropriate here?
Also.
I don't, first of all, the calling her at her business repeatedly when they told you not to call is unacceptable. Let's take that and multiply that by 3. You're continuing to call there after the police told you not to when they were at the property. On a scale of 1 to 10, that's a 10 that you still did that. You threatening to shoot up the place on a scale of 1 to 10 is 100,000. I don't understand these threats of violence out there anymore. In this day and age, when we got crazy people running all over the country that think that shooting people is fun, you don't threaten to shoot up a place. Maybe there's some demented human being in the world that would find that amusing. I'm not demented, and I don't find it the least bit amusing. Now, I'm telling you, you have any contact with that outfit over there, I'm telling you, you're going to jail for the rest of the probationary period that I can possibly give you. For the balance of the jail term that I can possibly give you. Do you understand that? I don't even know how to handle this no contact. They have children. How are we going to handle that? He scares the devil out of me throwing.
We don't have children. Daryl's behind us. Shoot. I'm not a threat at folks.
You threaten to blow up a building and people.
I will never see that lady.
Yeah, he no longer has any reason whatsoever to be in contact with the facility or anything.
I just don't know what to do with these anymore. I mean, somebody has a bad day and they think they can threaten people. I just don't get it. Probation 771. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. You're not to go near Brownstown Forest View, 19341 Allen Road in Brownstown. You're not to contact them. You're not to call them, write them, text them, email them, go anywhere near them. You're not to have any contact with Jacqueline Alayon. No contact with her at all. You're to attend a psychiatric evaluation and treatment if recommended. You're to attend an anger management program with 8-week follow-up. So again, you're not to go near Brownstown, Forest View, 19341 Allen Road in Brownstown. No contact with Jacqueline Alayon. You're not to possess firearms of any kind. You're not to possess dangerous weapons of any kind. You're to obtain and maintain employment, provide proof, and you're also to obtain a high school diploma or GED. You're to clear all your warrants within 30 days. Five-days court work program. There's a $35 a day charge for that for a total of $175. Fines $100, costs $125, 75 victims' rights fee, $50 justice assessment, $350 screening fees, $60 for 410. Probation fees are $240 for 650. We have court work program fees of $175. The total is $8.25. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. This could have been a lot worse. Do not do that again. Give me a review hearing date, please, Lisa.
September 3rd of 26 at 9 o'clock.
September 3rd of 26 at 9 a.m. Now, can he pay all this today? How much do you have today? I'm sorry? When are you going to be able to pay this?
In a week.
I don't need you to pay it all in a week. You pay $100 per week. How's that? Start at beginning on September 29th. Can you do that? If you don't have the money, you come to the court. I'll be glad to give you an extension, or you call the court on her before the due date, and I'll be happy to give you an extension. Whoa, scary. Good luck. You'll meet with probation before you leave. Todd Rutherford,
Thank you.
25R25319. Good morning, Mr. Shemke.
Pretty hard, but I'm preparing to get my plan and works to standing behind the about.
Your name, sir?
Todd Rutherford.
This is a disorderly charge.
Yes, Your Honor, there's a non-company case for Brownstown as well. It adds to this way for re-refine states.
I'll enter a not guilty plea. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol. There being an allegation that he was disorderly because he was intoxicated, at least in part. No alcohol. No illegal drugs, no marijuana, no contact with prosecution witnesses except through your lawyer. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You understand all that?
Yes, sir.
Do you have any questions? And we're going to give you October 16th. That's when you meet, right? Or
Yes, Your Honor, I was going to ask for the second, but I spoke with the prosecutor for Rock, and he's not here on the
that's
second.
fine. October 16th, please say at
8:30.
8:30. Okay. All right. So you can go down the hall, sir. They're going to give you a paper notice and we'll see you back here. Do you have any questions?
Your Honor, I believe that there's one other company case, Mr. Rutherford, up to date for the name as well.
Todd Jeffrey Rutherford. This is file number 25B149205A and B.
Good morning, Your Honor. Mr. Shemke, appearing to have my client's case, my legal.
Phone.
Whose phone was that? I'm sorry.
So we got another disorderly public in-text.
Yes, Your Honor, these the defense dates were back to back.
And then says he's got and we also got an animal cruelty case going.
Yes, Your Honor.
Do you have any idea what the allegations are?
No, Judge, beginning the rings.
Keeping or harboring an animal in the kennel or otherwise willfully or negligently caused or permitted the animal to suffer unnecessary discomfort or pain.
If I were to speculate, Your Honor, I believe that my client was driving away and a blood alcohol level come back, and I assumed that there was potentially an animal in the vehicle, but the animal was not injured.
But they've got another one here. Left his dog in a 2016 Dodge Ram. Vehicle was not running. The windows were up, the doors were locked, and the engine was off. Dog was beginning to show signs of distress due to the high heat index. Defendant refused to assist police in safely removing the dog. Police had to break the right rear window of the vehicle to remove the dog in order to ensure it would not continue to suffer unnecessary pain or discomfort. All right.
As the arraignment way forward, the arraignment stands being.
He's got on super drunk.
Chief's okay.
Where's the dog at now?
Oh, she's at the house. My dog is very well taken care of, sir. My dog loves me.
I don't want you to talk about the case at all, sir. You shouldn't. But this was August 6th. Now, unless we were having an unseasonably, and I don't want to talk about it, cool day for August 6th, that would be completely inappropriate. So let's just back it up here. Where's the super drunk charge?
It's in Brownstone, Judge. I've spoken with Ms. Caitlin Foley. We anticipate that case coming to fruition for the
Is
next.
that in front of me or Judge Heston?
Judge, it hasn't been
Charge.
hasn't gone for it yet. But with the blood alcohol level came back, I believe I spoke with Ms. Caitlin Foley, indicated that there'll be a date that it ends. The court, we're going to walk them in immediately after, so we'll be seeking to go.
I need another bond sheet, please. Are you married, sir?
No, sir.
Is there anybody else that lives at the residence with him, Mr. Shemke?
No, Your Honor. I know that he was married. He has fostered and kept good relations with their stepsons, and they're grown, and they know side of him.
This is getting a little bit more serious than I anticipated. What's your dog's name?
Sapphire.
These are all separate event states, were they not?
Yeah, nothing close in proximity, but side days.
All right, here's what I'm going to do. Everybody to just give me 1 second here. All right, on the B file, 205B, because I'm setting separate bond conditions. These are the bond conditions on this. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm going to give you your date again momentarily. You're to attend AANA twice a week. We're going to give you a form. You have to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. You're not to have any contact with prosecution witnesses except through your lawyer. You're not to own, possess, or harbor any domestic animal other than that dog. So you're not to acquire any other dogs. You're not to own, possess, or harbor any other domestic animal other than that dog, Sapphire. You're not to be on a SoberLink device by the end of the day. SoberLink device by the end of the day. I'm going to give you a court date, which is going to be on September the 18th as well on this one, Lisa. I'm sorry, on October the... What day did I give you?
October 16th, Judge.
I'm sorry?
The October 16th.
October 16th. And what time did I say on the other one, Lisa?
8:30, Judge.
Thank you. So that's when I'm setting all of these. October 16th at 8:30. And we will go from there, okay? Sir, do you understand all your bond conditions here?
Yes, sir.
Do you have any questions?
No.
Okay, so you can go down the hall and get your notice. You're all set. Make sure you go to AA. Make sure he gets on the SoberLink by the end of the day.
Understood, Judge.
He can talk to probation, okay?
Understood.
Thank you. People against Charles. Christian Saracen, 25R 514-180, 25R 514-001, 25R 514-237, 25R 514011.
What times?
Yeah, absolutely.
Morning, Your Honor, Mike Hill, Crawford, Deputy.
Your name, sir? So he has one misdemeanor outstanding, anti-blight ordinance. Does he stand mute, waive formal reading on that?
Correct, Your Honor.
Not guilty, pleas entered. He's had these other cases outstanding. I'm going to give you a personal bond, Mr. Saracen. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as direct. So I'll give you a personal bond. You don't have to post any money, but let me just cover one other thing with you. It says you're requesting an adjournment for compliance. So we're going to do
What, 30 days, Your Honor?
give me somewhere close to 30 days, Lisa, please. This is
October 16th at 9 o'clock.
October 16th at 9 o'clock. Now, I want to caution you though, sir. You do have outstanding tickets here that are going to need to be paid. You have 198 plus 198, which is what? 396 plus 165. So you're somewhere in the neighborhood 496.5. 56. It looks like 561. So somewhere in that neighborhood, you're going to have to pay those. You understand that, sir? Now these tickets, he's letting go. I mean, he's got June 23, July 21, June 9th. He's going to have to figure out a way to take care of this.
He's aware, Your Honor. He's going to be working on coming in with something for a payment arrangement.
If you want a court-appointed lawyer, you fill out a petition for one, sir. Do you have any questions? I can't hear a word you said. Okay, good luck. And then you'll go down the hall and get your notice. Thank you.
Fill out all the highway.
Do you have anything else ready or no? Or are we? We're almost done?
Yeah.
Caballero? Why is David Caballero? 25T646339. Name?
Caballero, Your Honor.
I have a charge that you failed to attend your scheduled probation visit on September 2 of 25. If you plead guilty or if you're found guilty, that will be your first technical violation. You could get 5 days. Do you understand that?
Guilty with reason, Your Honor. I understand, sorry.
All right, you understand that? And did you sign the advice of rights and read it and understand it? You plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? You wish to have a lawyer represent you? I'll give you one if you want one. You sure? To the charge you failed to attend your scheduled visit on September 2nd of 25. How do you plead?
Guilty
Did you fail to attend? Why? How? For what reason?
in jail or in the hospital.
What's that?
Either incarcerated, still in jail at the time of the
You have proof that you were in custody during that time? Here's what I'm going to do. I'm going to go ahead and enter a not guilty plea. I'll give you some time to go get that information.
Still didn't show, I still didn't report that. Maybe could have told, you know.
Just listen to what I'm telling you. Just listen to what I'm telling. I want proof that you were in jail or in the hospital on September 2nd. So I'm going to enter a not guilty plea, okay? I'm going to enter a not guilty plea. I'm going to give you a $250 bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
One thing I cannot afford is $250 bond.
There is no bond. I'm giving you a personal bond, okay? I'll just make a note. Defendant said he was in hospital on 9/2
I
or
believe I was incarcerated.
in custody.
Yeah.
To bring proof. Mr. Listen to me. Aren't you going to get tired of going to jail?
And speaking all honesty to you, and you're a honorable man. I've seen had many days with you, and I believe more honorable than some judges I've taken in front of. We're not talking about Ms. Holmes.
I don't need to talk about me or other judges. I just want you to know, aren't you tired of going to jail?
Yes, Your Honor. I just got out of metropolitan behavioral health. I think that you should know about it. I think other people should know about it. It's through Corwell and United Health Service. I have not felt this clear-minded since I left.
Good. Do you have a report from them?
Still current. I don't have a report from them.
Okay, get it.
I'm still currently under partial hospitalization. And they were supposed to pick me up this morning. This is a godsend. I didn't even know I had to show cause today. And they were supposed to pick me up this morning. They didn't. For some reason, they missed it. And then my mother was taking me and she got really thrown while she was taking me. So I decided I didn't want to be in the car with her that long. So I decided to come to the courthouse, and I just so happened to be my show cause at 9. And I'm taking responsibility for what I've done. I'd like to get on the right track and move forward with my life.
Well, that sounds good. You were so young. How old are you again? If you behave yourself, you're gonna have 50 more years on the planet, at least 40. Son.
Behavior.
Okay, well, that's fair. All right, Lisa, give me another date. I want you to go get proof of this, okay? What day are we gonna do this with him?
September 29th at 9:15.
Is that gonna give you enough time?
Yeah, I have to go there Monday through Friday.
Fine.
30 to 2:30.
September 29th at 9:15. Bring proof that you're either in custody or in the hospital at the time of your probation visit, okay? All right, best of luck. Stay just one day at a time.
I just went to a meeting at Place Serenity last night at 8:30. Got my 24-hour job.
Great. Just work one day at a time.
Can I say something off the record?
Well, everything's on the record. All right, take care.
We are on the record in the matter of the state of Michigan versus Todd Myers, 192621. And then we have 2415472552.
Good morning, Your Honor. Neil DuBois on behalf of the defendant. This state your name, Mr. Myers. Todd Myers.
All right. Good morning. And I know you've been here for a bit. I apologize for your delay. Mr. DuBois has been pulled in many different directions today.
Good.
And as I stated, the jail individuals have to take priority. So, all right. Now we are here today for on the 1-9 case. We are here for a pretrial. So did you handle the pretrial on that one? And then on the other two matters, we are here for sentencing. So one of those is assault and battery. That's the 251547 with Chance Alvady as the named victim. Is Chance here? No. And then also breaking and entering without permission. That's the 25-52 matter with, I believe, the same individual. All right. And counsel, I also understand that your client has Detective Haskins that would like to address the court as well as far as that. So let's handle the pretrial first, and we can do a global sentencing on all of them.
Thank you.
All right. So as to the pretrial, counsel.
An opportunity to review this with the assistant here in my client for a guilty plea to the defense charge of failing to display the ballot box in charge of driving license suspended and dismissed.
All right, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
I do.
All right, and you heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of fail to display a valid license, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea, you'll be waiving some of those rights.
Yeah.
You understand the possible penalty as a result of your plea, this court, any other court or administrative agency. And and knowing all that, you want to continue with your plea, correct?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
All righty. And counsel, if you can please forward your client.
Yes, well, Mr. Myers, you recall being in the city of, I believe it's Wyandotte, Your Honor, on or about.
That would have been Wyandotte, yes.
Yeah, the city of Wyandotte on about the 10th of August in 2019.
Yes, that was the date. The question was to you,
So
sir.
you recall being in Wyandotte at that day and time, and you were asked, you were in a motor vehicle and you were asked to display it to produce your a valid driver's license. Is that correct? Yes. And you weren't able to do so at that time. Yes. I'm satisfied with that.
All right. The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea to the amended charge, dismiss the original charge per the plea agreement, and counsel. Then we'll handle the sentencing on that with the other matters.
Yes, sir.
And so you had an opportunity to review the pre-sentence report and recommendation with your client on the two matters for sentencing, correct?
Yes, Your Honor.
All right. And counsel?
Yes, we reviewed this in some detail. Mr. Myers has had some run-ins in the past with the law. He's committed himself to stay on the straight and narrow yes. He is in a rehab program currently. What is that program, sir?
It's in West, it's called a beginning step.
Beginning step?
Yes.
So again, he is seeking help from professionals. The incarceration that's recommended, I would suggest that the court use that as a tool, hold that over him, that is for review, hold any incarceration in advance, but prove himself a little bit to the court, and then return on another day with good news. And he's managed to stay on straight and narrow. Yes, but yeah, the information in the report is indicated exactly. He's a full-time employee. He's taking care of his, was it a son?
Yeah. I'm sorry, I didn't hear that.
Yes, 13-year-old son.
Okay.
And so he feels he's got himself on the right track at this point. So let's keep that up. So with the court's guidance and supervision, I think that would help him to do that. So rather than asking to hold any frustration in advance, addressing the new matter today that he pled on, we suggest that fines and costs would be adequate under the circumstances for amending the charge. Yeah. Oh yes. And as the court's aware, he has done approximately 20 years in hits. Suggest that the assessment of a fine sure will also be done that are added a punishment. And he's also currently on a GPS tether. Yeah. He's on a GPS tether. And as far as I'm aware, there's been no violations.
That's correct. I believe, let's see here. Okay. Sir, when's the last time you consumed any alcohol?
That's in January. I went to rehab.
So how are you doing with that, sir?
I'm doing fine. Emotional rate, I gave up. I don't want to do it no more. It was ruining my life. We're sitting in bad place during that time.
All right. And I understand that you have Detective Haskins to speak on your behalf, correct?
Yes.
All right. And Detective, your name for the record, please.
Jane Haskins, please. H-A-S-K-I-N.
All right. And what would you like the court to know?
I just want to make some comments on behalf of Mr. Myers. I encountered him twice during my employment at the city of Riverview. Once last year, in the summer, on a traffic stop when I was on road patrol. Mr. Myers was cooperative, respectful, made it easy to do our investigation. And then we knew we had warrants for him while I was in the detective bureau. We got information that he was in rehab. So we elected to not bother him in his rehab or tamper with it, let him finish the program. And then when he was apprehended on his warrants later on, I believe it was August, I was able to interview him on a separate case, determined he was not involved with that case. Again, he was respectful, cooperative. And seeing him between last year and this year, there's definitely progress. He's healthier. He's working, completed rehab. He's landscaping. It's a busy time of year. He's making money, trying to get back on track. So I just asked the court, to keep that in mind, and I'd hate to see him go backwards from where I've seen him come from to today.
All right, thank you.
Yeah.
And I'll say that's the first. I haven't had a detective speak to the court on behalf of the defendant at sentencing. So, Mr. Myers, that says a lot.
I saw him in the lobby, and he left a good impression on me, so I went and said hi to him, and I wanted his sentencing was today, so I figured I'd stick around and see if I can help out.
Nice. Wow. So he even solicited you. Look at that, Mr. Myers. So that speaks volumes, Mr. Myers. Not that your attorney isn't a good attorney in his speaking and whatnot, but it speaks volumes, right? Because Detective Haskins has had interaction with you on a number of occasions, and he himself has seen the progress that you've made. Can you get Mr. Myers a napkin, please? And sir, you should be proud of yourself that you have a detective that not only recognized you, but is willing to speak to the court on your behalf with how much progress you've made. But you should be more proud of the progress you've made.
I am.
Okay. So, fun fact, the court loves forward progress, right? Whether in life or on the football field or, the ice rink, whatever it may be. So what we're going to do, sir, is we're going to do this. I'm going to order 90 days jail. I'm going to suspend that jail. Okay. Which means that you will determine your final outcome. It's all in your control. Okay. And you are going to continue with what you're doing. And what we'll do is we'll do what we call a jail review, which means that you'll be coming back every so often to just kind of check back in. So I can lay eyes on you, make sure that everything's still moving forward. You're advancing down the field, right? And we'll go from there. Okay. Sure. You're welcome. So I'm going to order on 2552. I'm going to order 90 days jail. How long did you say? What was the time you were in custody, sir?
20 days.
20 days.
That is for like 16, 17 days.
Okay, so were you in custody for 20 days?
Yes.
Okay, 20 days credit. So that leaves 70 days, sir, on the table. So if there's any deviation, right? So here are going to be your conditions that you need to comply with, okay?
Okay.
You're going to continue with your recovery treatment. You're going to participate in random testing. Are you already doing random testing? I don't remember.
No, I already know. I was though, but I'm not anymore.
Okay.
Something good.
Okay. And so we're going to do random testing just to kind of help keep you accountable,
Perfect.
right? So, I will remove the GPS tether. And I'm going to also have you start participating in fan meetings once per month. I think that would be very helpful to you. Are you familiar with fan? Okay. So it used to be called Families Against Narcotics, but it's changed its title. And so it's Face Addiction now. And so it meets once a month. And the Downriver chapter is the third Thursday of every month. And it's at 5:30 or 6:00. And it's a way so that you can get additional support to maintain sobriety as well as additional recovery resources. There's usually a different speaker every month and kind of helps with different life skills and such. And there's a wide variety of members that people that attend, right? It's people that are in addiction, people that are in recovery, people that have lost family members to addiction, people that are family members that are supporting their individuals in recovery, kind of a whole, then community leaders as well. So there's a wide variety of individuals that attend that. So I think that'd be very helpful for you in maintaining your recovery. Okay.
Thank you.
You're welcome. Okay. So, there's been $0 in restitution requested, so I'm not going to order that either. All right, then obviously, I think it goes without saying that you're not to possess or consume any alcohol or drugs that are not prescribed. So, anything else?
I just want to say thank you. And this day, we come back to O'Neill and beginning step to speak. Like 3 more months.
Good.
I'm nervous now. I'm doing that.
Good. All right. All right. Well, very good, sir. So that's going to be your sentence. And so what I'm going to do, just for a little bit of added incentive or motivation, I'm going to indicate that the sentencings in these matters are consecutive, which means that you're looking at 140 days as opposed to 90 days or 70 days, I should say. All right. So, now the conditions are the same. I'm not, they're going to be duplicated, not necessarily extended. Does that make sense?
Yeah. Yes.
Okay. Okay. So give me just one moment so I can write this in and then I will assess the fines and costs. Okay.
Okay. I have a question when you're done.
Yes.
Where's the fan located? What city?
Lincoln Park.
Okay. Most brother, I was like, this fan.
Yes, well, it's typically at one location, but sometimes they change location. So probation, you're going to go meet with probation before you leave today.
Okay.
And then they're going to give you some of that information. Okay. And I believe there's also a Facebook page. I don't know if you have Facebook. I think that there's a website also. And then let me set the jail review date as well. Let's set this for November 6th. Okay. I don't want to go too far out right now.
Okay.
9 a.m. All right. Let me, and where in your, where are you at, sir, with your treatment?
Yeah. Very good.
Well, that, and also the location, are you Oakdale or you, I thought you said what, Wellness, Western?
It was beginning step.
Oh, beginning step. Okay.
Now it's one Westland, Nolan, beginning step, and
Okay.
I just said it too much for that. I'm sorry.
That's okay. And, so how are things going with your child at home?
Well, man, I haven't seen him like last time I saw him. He was was speaking with still, and I don't know if it was the deep in mine. Yeah, I started running stuff. I ain't seen him in a while. That's good though.
Good. And so how often do you see him?
Whatever I'm with.
Okay, good.
My ex wife, she don't mind. She's out of a good head. We just broke up like 2015. So I'm 9. Ready. But she didn't mind if I could meet him and whatever.
Right. Because you're in recovery and you're a good asset for your child.
Actually trying, yeah.
Right. Okay. So very good. All right. So what the court's going to do then is on 2552, the court's going to order a $300 fine, $100 screening assessment fee, $300 supervision oversight fee, crime victim assessment fee of $75, justice system assessment fee of $50. That's a total of $825. And then on the 251547, it's 241547. All right. It's 241457. 547. The court's going to order a $200 fine, $100 screening assessment fee, $300 supervision oversight fee, $75 crime victim assessment fee, justice system assessment fee, $50. Total $725. You also, sir, just so you know, you have $420 left from a 2010 matter. So you'll have to set up a payment plan. We have you set up a payment plan for all of these. All right. And I know it's when you total it up, it's a large sum of money, but even if you can do $25 a month, that will be, you're making a diligent effort to do something. Okay.
Got money too, and that's what, you know what I'm saying? Saving money, having money, we don't do anything like that. Drink maintenance, all that other stuff.
Okay, very good.
Might as well I want to take care of it all anyway. Just tired out of this stuff on my back. Weighing me down.
Okay. All right. And then on your, on your fail to display, I'll do a $200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50. Is there a warrant fee on that one, Ellie?
$50 warrant, $45 clearance.
Okay. $50 warrant fee, $45 clearance fee. So it's $620 on that one. Okay. Now you did post a bond on, nope, that one forfeited a long time ago. Okay. So, do you have any money that you intend on paying today?
No, man.
Okay. No, that's okay. So what I'm going to do is I'm going to, you're going to go to probation. They're going to process all of this. Then I'm going to have you go to the window. I'm going to have you speak to Sue. Okay.
Okay. I also got my license back too.
That was going to be my next question.
Yeah, I got it back about 3 years now. I am.
Good for you. Doesn't it feel good?
Oh my God, yes. I was driving when I was down for a while. I was back in the past. I got a fleeing and losing charge back, and I didn't really. I was just like scared, so I didn't want to get in trouble. I just wanted to bring my wife's car back to her and get it there. I was stopping at stop signs and all that stuff, but stupid thing to do anyway, because that's why I lost them. But I worked hard. I got them back though.
Very good. Okay. So, sir, I'm going to have you, you're going to go to probation. Then you're going to go see our cashier. Her name is Sue. Okay. And then you're going to set up payment plan on all of these matters and the one that is still outstanding from 2010. Okay.
Okay.
All righty.
Thank you.
You are welcome. Good luck to you, sir.
Have a good day.
Thank you. You as well.
So just go there to the probation.
You're just going to go over to probation. Okay. Thank you, Detective Haskin.
Yes.
Okay, let's go on the record in the matter of the state of Michigan versus Aner's Treegoods, 25662A.
Thank you, Iron. Treegoods P83336.
Thank you. And sir, your name for the record, please.
I know Treegoods.
Okay, thank you. And so, counsel, today is the date scheduled for sentencing on your client, on your client's plea to an amended charge of OWI. The original charges of operating while intoxicated, second offense, and refused PBT were both dismissed by way of resolution between counsel. And have you had an opportunity to review the report and recommendation, counsel?
Thank you, Your Honor. And yes, at this time, we did have the opportunity to review the substance abuse screening assessment report recommendation. At this time, there are no additions, corrections, or deletions to be made. I did go over the recommendation for 24 months of probation with certain terms and conditions. And if the court would allow just a short elocution on behalf of Mr. Treegoods.
Yes, but first I have a couple questions because I thought your client was living in Columbus. This says he lives in Wyandotte,
You live in Columbus, correct? Correct. Okay.
right? Because he works down there.
Yeah,
I presume it's a long commute from Wyandotte to Columbus every day.
Yes, he still does come back to Michigan because his wife resides at Wyandotte. I'm not sure have you changed it on your, have you officially moved down there? Yes. Yes, okay.
Okay. So that's a correction. I don't know what it is. Did you tell probation you moved down to Columbus or did you tell them you lived in Wyandotte?
I told Michelle, not the lady, and I spoke to her, yeah, it was the Columbus is.
Okay. Okay. My next question, sir. I'm sorry, that was the only question. I have other comments, but I'll wait till council after you finish.
Thank you.
You may proceed.
Thank you, Your Honor. Your Honor, Mr. Treegoods here has just indicated he does currently live in Columbus. He is employed now down there. Since being employed since the start of this matter, Mr. Treegoods is doing so much better now that he's actually involved. I really think a lot of this stemmed from the fact that he lost a job that he was passionate about, which ultimately caused him to make poor decisions, spiral. Once he was able to become employed doing the same thing, it's really elevated him into an understanding of where he was at in that depression. He's currently enrolled in the Ohio Professionals Health Program, which is a 2-year program to help with his outstanding alcohol issues, but a lot of his mental health issues as well. On top of that, he's currently enrolled in an intensive outpatient program through Ridge, Ohio, as well, which I believe is a 2-month base program. So he did, as of course, where was it ordered in bond or anything like that? I believe part of that is through, is it through your employer that you found that?
It's through the, Ohio.
Which I believe he was able to get him due to his profession, Your Honor. So he has taken steps to correct a lot of the issues that he has. I know the recommendation is for him to serve 10 days in jail. We are asking the court not to adopt that recommendation. Although, jail is reserved for individuals that are repeat offenders or have ongoing issues where they don't follow direction or court orders through probation. I think in this situation, if Mr. Treegoods would be incarcerated, I truly believe it would put him right back into the same place that he was in. He would lose his employment. And really, I think he'd fall right back into the same spiral that he was in, and he's been working diligently to get out of. I feel like a broken record every time I'm in front of this court regarding this matter. We always indicate how well he's doing, but it truly is just from when I first met him and his wife to now. There is an extremely noticeable difference of how he talks, how he carries himself. I truly do believe that everything he's been doing in Columbus has been helping. Another thing on here we would ask the court not to adopt is the ARM weekend program. And the reason being is because one, he lives in Columbus, but 2, he's already involved in 2 different programs now that are going to go past the point of probation at this point. And I think it's something that Mr. Treegoods is glad that he's a part of. He really is getting a lot of help down there. And so we would just ask the court to take that into sentencing here today, Your Honor.
Okay, thank you. Can you tell me again the name of that program, the 2-year program, Ohio Professionals?
It's called Ohio PHP.
Which stands for Ohio Professionals Health Program.
And then what was the 2-month one? I missed that name.
The Ridge, Ohio Intensive Outpatient Program.
And when did you begin the Ridge, Ohio program, sir?
This week.
Okay. And when did you begin the OPHP? Did you already begin the Ohio Professionals Health Program, or did you?
Well, the Ohio PHP sent me. I have to complete this the JOP program first, and then I will join the
Okay.
PHP program after I complete that.
Got it.
The PHP sent the recommendation to the PH program.
Okay.
Sign up.
All right. And how are you now? Season started back up, right?
Training can start.
Training camp, right? Okay. And so I understand that's your passion, right? The your profession and hockey, right?
Yeah.
So and I would agree that Mr. Treegoods that he definitely seems different than when he's been here the last on all the other matters that you've been here before. And I gotta tell you, sir, I don't even know their level of 0.223 blood. I don't know how you were able to even balance on a motorcycle, let alone drive a motorcycle.
Yeah.
And then you fell, got back up, and you continued driving. And so I'm glad that you weren't significantly injured in the crash, nor was anybody else. I think some trees and bushes may have been in the way at some point, but I think that all of that happening when it did, I think it did you a favor, because I think you were able to see the significant consequences and how close you were to not being able to be here to live out your passion, parent your children. So what the court's going to do is the court's going to state the following. After hearing from counsel, from Mr. Treegoods, from reviewing the report and the recommendation, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Treegoods and the legislative guidelines. The court's going to order 10 days jail. I'm going to suspend that jail. Okay, so you're not going to serve it right now. You may not ever serve it if there aren't any violations. If there's violations, that jail's right back on the table. Okay? Right. 24 months probation. You are eligible for early discharge, and I'll go over that shortly. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. And let me clarify that you're not to leave the state of Ohio without consent of the court. So I understand that you go back and forth for parenting time and whatnot. So you'll just have to kind of set those days in advance as much as possible, and then just communicate with your probation officer that those are the days that you're intending to travel back and forth to Michigan. Okay.
Your Honor.
Now, I think
Schedule 2 is employment schedule.
well, that was my next question. I presume you travel with the team. Okay. So you will have to get your schedule as much as possible. Do you do it for the whole season, or is it only month by month? What's that?
Whole season.
Okay. So you have to supply that to your probation officer so that you can all be in communication. So then, because I'm sure that typically they try to do, I feel like they do like trips out west. So then there'll be maybe like a slew of span of 10 days or something where you'll be out west with the team. So then, if that were to be the case, then you may just have to find a testing facility in that area, depending on where you're at. depending on how long you've been gone. So you'll have to stay in communication with your probation officer about that. Okay? We're not going to prevent you from traveling with the team for your job, but we still want to just make sure there's some additional levels of accountability.
Thank you, Your Honor.
Okay? All right. And then also you're to notify your probation officer immediately of any change in address or employment status. You're not to possess or consume any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to participate in outpatient substance use counseling. What I'm going to do is I'm going to indicate that you are to complete your Ridge, Ohio program. And then the Ohio DHP. Okay, so you don't have to do something in addition to that because I believe that will accomplish all those goals.
Thank you, Your Honor.
The rehabilitative goal for that condition is so you can have assistance in providing coping mechanisms so that you may maintain sobriety and prevent relapse, hopefully preventing this matter from happening again. Okay. The court's not going to order the ARM weekend program. The court's going to order you to participate in the MAD victim impact panel. I know you've done that previously, but maybe now that you've been in an accident, you may have a little bit of a different perspective in your participation in that. The rehabilitative goal for that condition is so that you can further increase your understanding of the dangers of driving while under the influence to educate you about the consequences of such behavior. The court's going to order you to participate in your NA meetings, your AA meetings per week. Your AA meetings. I believe you're already doing those, right? Okay. The rehabilitative goal for that condition is to help give you additional support in maintaining sobriety. And the court's going to order fan meeting once per month or its Ohio equivalent. The rehabilitative goal for that condition is to give you additional recovery resources and sobriety support. Now, counsel, if you can help your client, I don't know. I know that FAN is a national organization. I don't know what states or locations they have chapters in.
Okay. I'll look it up.
Okay. Obviously, if you're traveling with the team for work and you're in a location that doesn't have that, then obviously you'll just have to work to try to find one when you return back to Ohio or another state that has a chapter. Okay. And then mandatory additional incarceration for any probation violation. Any questions regarding those conditions?
No.
Okay. The court's going to order a $500 fine, $100 screening and assessment fee, $1,200 supervision oversight fee. That's $50 a month at 24 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $22.25, I believe, is that cost. Do you have any, actually, I'm going to have you set up your payment plan through probation, okay?
Thank you.
As I did indicate, sir, you are eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay?
Thank you.
So, Mr. Treegoods, I wish you luck. I wish you well. Just so you know, if you ever want to come see us, you don't have to do it this way. You can always just stop in and say hello. We don't have to get arrested for something.
Oh,
Okay. And I hope you do very well keeping the players in shape, except when you play the wings. Okay. All right. Stop over at probation and somebody will be with you shortly. All right. Have a good day. All right. And let's go on the record in the matter of the state of Michigan versus Nolan Muzin, 251036.
Good morning, Judge. John Cahalan on behalf of Mr. Muzin, who appears via Zoom. Mr. Muzin, you want to state your name for the record?
Nolan Muzin.
All right, thank you. And so, Mr. Cahalan, you are currently in your car, but you're not currently driving. Is that correct?
That is correct.
All right, thank you. And Mr. Muzin, you're also in a vehicle, but you're also not driving. Is that correct?
Correct.
Okay. And so the court will note that the court spot appointed Mr. Cahalan after appointed services was not going to appoint somebody, and we had Mr. Muzin here. And counsel, you're able to have a conversation with Mr. Muzin, correct?
Correct.
All right. And what's happening today, counsel?
Judge, we're asking for an adjournment of today's probable cause conference, just based on the spot appointment this morning, and I needed to speak with Mr. Muzin a little bit further.
Okay. Okay, and so counsel, does October 2nd work?
Yeah, that works, Judge.
9:15 a.m. Bond and conditions are continued. Mr. Muzin, if you were to test right now, what is in your system?
There shouldn't be anything. Excuse me. I'm not sure how long things stay in my system for, but I haven't I've been enjoying sobriety. So I actually do appreciate the court for kind of forcing me to take a second look at all that. I did actually want to ask how to get more information on the fan program.
The fan. So you can, do you have Facebook, sir?
I do, yes. I'm actually
Okay.
I'm in the court parking lot, so if probation has information on it, I could pop in there too.
Probably easier. Yep. Just pop right back in the building.
Okay, awesome.
Okay. All right. Thank you. Bond and conditions are continued. We'll see you back in 2 weeks. I apologize for your delay today. Thank you, counsel, for accepting that spot appointment.
Sure thing, Judge.
Thanks. Anyone you can fix this for me?
What?
This isn't working for me. I don't know if it's empty.
Yeah.
Might be towards the end. I don't know. Sometimes it doesn't work. All right, let's go off the record.
And I was able to speak
and
with
then-
Mr. Christmas. I'm sorry, Judge, I didn't mean to cut you off. I don't know if you were talking to me or not, but if I could just get back with Mr. Muhammad on Christmas. Thank you so much.
Okay, you're welcome. All right, let's go on the record in the matter of the state of Michigan versus Sabrina Hamadi, 25743 A and B.
Good afternoon, Your Honor. Mohammed on behalf of the people. And thank you. Good afternoon, Your Honor. Good afternoon to your staff. On behalf of Ms. Sabrina Hamadi.
All right, Ms. Hamadi, if you can please state your name for the record.
Sabrina Hamadi.
And I do apologize for the delay, ma'am. We were in chambers having a discussion about this. So, all right, counsel.
Your Honor, thank you. Mr. Mohammed and I did have discussion in chambers. We are still awaiting the approval for the potential resolution of this matter from Mr. Mohammed's supervisor. We have submitted everything prerequisite and required to see if we can get an offer in this case. With that being said, Judge, it's my understanding that we'll have an offer by Tuesday, and that if there's not going to be an offer, Ms. Hamadi we can waive her presence to be here for a motion hearing if we're going to proceed with the motion, unless or otherwise we're going to have her appear via Zoom for a potential plea hearing next Thursday at 12 o'clock.
All right. So, and Mr. Mohammed.
That is all correct.
All right. And the court will also note that it did, I think, make some very firm statements as far as adjournments and things of that nature. And the court will note that this matter will be adjourned next Thursday, September 25th at noon. Either something's happening that day. Either a resolution is going to be placed on the record or the motion hearing is going to proceed. If the motion, either way, the prosecutor is to notify the court and defense by September 23rd as to whether or not it's going to be a hearing that's going to be held or the resolution. That way, counsel can notify his client accordingly, and then this court can be prepared with a motion hearing being or proceeding forward.
Thank you.
Okay. Bond and conditions are continued. And Mr. Muhammad, just make sure you're submitting that response then. Just submit it just in case. Just in case. Okay.
Thank you, Judge.
All right. Thank you. Have a good day, ma'am.
Thank you.
Thank you. You too.
Thank you. All right. Oh, sorry. That was your Oh. All right. So, Mr. Cahalan, are we ready on Kessel Loop? No, no, that wasn't Mr. Hold on.
No, it's
Christmas. Are we ready on Christmas?
yes, Judge.
All right. Can you get the Christmas file?
No.
Thank you. All right. We are on the record in the matter of the state of Michigan versus John Christmas, 251-330.
Good afternoon, Judge John Cahalan, P77404, on behalf of Mr. Christmas. Mr. Christmas, if you could unmute yourself and state your name for the record.
John Christmas II.
All right, very good. Thank you. And so, counsel, you spoke to the prosecuting attorney, correct? And I know this was also a spot appointment.
Correct. And I've advised my client of what's going on, and he would like to proceed to set this matter for a preliminary exam. He'd also like me to address bond.
Okay, we will set this for preliminary examination. Counsel, are you waiving time or are we doing this next week?
Let's see. The 25th is a pretty bad day for me, Judge. So does it have to be a Thursday?
Yes, it has to be a Thursday.
Okay. Could we do, let's see. Thursday, October 23rd.
October 23rd? No, we can't go that far out, counsel.
Okay. How about, I guess I can try for October 9th then.
Does October 2nd work? Because I'm anticipating you're going to ask for bond reduction, and I don't anticipate I'm going to hear anything that would change this court's position from the original bond it set, but I'm still willing to hear arguments. So with all that, I don't know that your client will be out of custody. So
yeah, I
the first, I mean, that adjourning it to setting it for October 2nd would be 2 weeks out. Can you do
Okay.
October 2nd? We can do it in the afternoon.
Yeah, or later in the morning would be ideal, Judge. On
Okay.
October 2nd, I can make that work.
Can we do 11 o'clock?
Yes, that works for me, Judge.
I'm sorry, what's that?
We have one in 11, so we can do 11.
11:30, counsel?
Sure.
All right, and counsel, that will technically be outside the 21 days. So if you'd like to go over the waiver of time with your client on the record, please.
Okay, Mr. Christmas, you're entitled to have an exam within 21 days of your arraignment. Setting this for an in-person exam, preliminary examination on October 2nd at 11:30 would take you a little bit outside of that 21 days. Are you okay with that?
I would like for it to be as soon as possible, so I'm not in here.
Well, the next week, I cannot make happen. So the court does their exams for state cases on the 25th. So, or I mean, not the 25th, but Thursdays. It's my understanding. So
I'm sorry if I'm ignorant to the law, but I'm not understanding if I'm supposed to get it within 21 days of my arraignment, why do I have to wait to go outside of it and make it longer?
The only other date.
I'm not adverse in the law. I'm sorry.
Excuse me, counsel, let me just step in for one moment. Mr. Christmas, the law says that you are entitled to have your preliminary examination within 21 days unless that time is waived. Now, based upon the date that you were arraigned and when Mr. Cahalan can appear for your preliminary examination, that would make it 2 days past your 21 days. That'd be at 23 days. So that is why we are having this discussion on the record, because you have to if you're going to waive your time, it has to be done on the record. And assigned counsel division did not send an attorney, so we contacted them for a spot appointment. Mr. Cahalan was spot appointed on this matter. So this is the very first time that he's appearing in this matter. And he's indicated based upon his schedule that he is unable to be here for an in-person exam on September 25th. Now, I can also tell you, sir, that sometimes matters are set outside the 21 days based upon discovery, whether or not discovery has been received, or there may be some voluminous discovery that still needs to be referred or reviewed, and that's not done. So there are oftentimes exams are held outside the 21 days. Now, if you want to agree to have it outside the 21 days, that's what Mr. Cahalan is asking, if you are consenting to have it on the 23rd day as opposed to within the 21 days. Because as Mr. Cahalan stated, he is correct. These are only done on Thursdays. That is the date that we have the state prosecutor at the 27th District Court. Does that clear things up a little bit for you, sir?
A little. Like I said, I apologize for not really understanding the law. I know you're trying to break it down to me, but yeah, I'm not really sure. Like I said, like he said earlier, I would like if there's a way that he can discuss the bond, because I feel like that's kind of like an unfair amount for me to have to pay. I think it was 25,000, 10%, 250.
Mr. Christmas, just for a moment. First, we have to get through this waiver. Mr. Cahalan, would you like a moment to speak to Mr. Christmas in a breakout room again?
I mean, if the court would, I guess I could try and get there on the 25th. If the court would do 11 or 11:30.
Let me see what we have on. Okay. Allie, what do we have on?
We can do 11:30.
We can do 11:30.
Okay.
Okay.
I'll do my best to make that work. So then that covers the waiver. It's not going to be outside the 21 days.
It'll be within the 21 days. Okay. So, 9/25/25. Witness and exhibit list by September 22nd. All right. And then counsel, you wanted to address bond. Bond is currently set at $250,000, 10%, with the following conditions. No contact with Yvette Manjojano. That's phone contact, text message, email, social media, third party, anything. Not to enter the premises at her property. Not to possess or consume any alcohol or drugs unless prescribed. Not to possess or have access to firearms and or any weapons. And not to be released without a Wayne County Jail, GPS tether, no house arrest.
Yes, Judge. My client's advised me he has no history of not showing up for court. He has no holds in any other court. He was candid with me that he does have a little bit of a criminal history, but he told me that he doesn't have any convictions from a significant amount of time. He is able to post a cash bond, but he's not able to post 25,000, 10% of the 250. He does have some family support. He lives by himself. His mother and his sister, he's advised me, believe are in the courtroom. At least that's what Mr. Christmas told me. So he's got some good family history. He will be showing up for court. He's prepared to meet all other conditions. Even if he had a house arrest, Heather, to stay in his house until then. He just simply cannot post the 10% $250,000.
Okay.
Consider a reduction.
All right. Well, the concern this court has is number one, Mr. Christmas is on probation to this court. And Mr. Christmas also has a criminal history that involves assaultive crimes. And the court also is aware that there's, I believe he lives with his grandmother, who also had been a named victim in a prior matter. In that matter, did the people want to respond to the request to amend bond counsel?
Yes. And good afternoon, Your Honor. Mohammed on behalf of the people. The people would object. I believe the defendant poses a danger to the public based on his past, which included a prior conviction for domestic violence. And he also has a history of riding while impaired.
Excuse me. Members of Mr. Christmas's family, I do not need any nonverbal communication or body language. Okay, just please, you're here. Just sit still, please. Thank you. You may proceed, counsel.
Thank you. And just to follow up, I believe in this specific case, I believe the alleged facts are that the complaining witness was held down by her chest and her neck, where the defendant had used his hand around her neck, which caused the witness to have difficulty breathing and causing bruising. So based off of the defendant's past, which included a assault in the past, as well as the operating while impaired, the people would object to modifying bond because I do believe he poses a danger to the public.
All right. And the court would agree with that because that is why the court set the bond at it's set at $250,000, 10%, as well as the bond conditions that it put forth. The court does have serious concern for the safety of the public. This is the fourth or fifth time that that Mr. Christmas has been in this court. And again, Mr. Christmas is on bond or is on probation in this court as well. So for all those reasons, the court's going to deny the request to amend bond, and we will see you all on September 25th at 11:30 a.m.
May I speak, Your Honor? Please.
I've already ruled, sir. What is it you'd like to tell the court?
I would like to tell the court that I do not feel like I've posed a threat at all. I have been working at Speedway for the last few months. I have not dropped dirty or anything with my probation. I've completed all of the assignments that I'm supposed to be completed with probation, including the MAD course and everything that's included other than just having to pay it. And then the matter with me and my grandmother are on very good terms.
Sir,
she did come back that one day and you spoke to her.
Sir, Mr. Christmas, I can understand that you don't have any current violations of your probation conditions. However, the charges in this matter are significant. The court has serious concern for the safety of the public and the complaining witness in this matter. And therefore, the court is keeping its bond and conditions as it is.
Your Honor, I'm the one that called.
Bond and conditions are continued, and we will see you next week.
Thank you, Judge.
Thank you. Have a good day.
You too.
All right, we are on the record the matter of let's see, matter of Jabari Palmer, 2412448 and B. A, sorry.
Ari? You must step down, Your Honor.
Okay, we'll recall this matter, and then we will be on the record in the matter of the state of Michigan versus Ian Vargo, 241129 A and B. A. Just A.
Vargo, please step up. Your Honor, you'll like here on behalf of Ian Vargo. Mr. Vargo, please state your answer.
Ian D. Vargo.
Ian. Okay, I apologize. All right, I apologize for your delay today, sir. I know you've been patiently waiting. Mr. DeBlois has been all over the place. However, you do not have to wait as long as we had to wait for you to show up to take care of this matter. So I'm glad that you're here to take care of it. And counsel, as to the arraignment, is this an arraignment pretrial?
Already, I thought he had already been arraigned.
Well, let me double check here. No, every time it's been scheduled, he's failed to appear. So
Very well then, Your Honor. Respect the arraignment, kind of waive formal reading stands to you to the charge.
all right, waive formal reading, enter a plea of not guilty for purpose of the arraignment as to the pretrial.
Yes, my client's prepared to offer a guilty plea, which I think is count. Frankly, I don't know which count it is. If
Well,
license suspended
count
first.
A.
Charge would be dismissed.
He has two of the same. But okay, so we'll do count A1. And then we'll dismiss count A2. Count B is defaulted. Okay, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the charge of driving while license suspended, second offense. Wait a minute. Let me just see here, because I'm not sure. Okay. Operating on suspended first offense, how do you plead?
Guilty.
And you've gone over your advice with your attorney, correct? Are you picking them up?
Not bad.
You have to speak up a little bit.
Yes, Your Honor.
Okay. And you understand by entering into a plea that you'll be waiving some of your rights.
Yes, Your Honor.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes, sir.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? Any immigration issues? And counsel, if you can please word your claim.
Yes, Mr. Vargo, you recall being in period of blind out on about the 2nd of August of last year?
Yeah.
At that time, you were driving a motor vehicle and you were pulled over by a police officer?
Yes.
And at that time, your license.
You keep your volume up, sir.
Yes.
And at that time, your license was not valid. It had been suspended. But
I believe so.
thank you. Your Honor said.
You believe it to be correct?
Yes. Yes.
Any reason why that would not be correct?
That's great.
Okay. The court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to count A1, driving while license suspended first offense, dismiss count 2, and as to sentencing counsel.
Your Honor, my client is in the process of rectifying. He had some issues with some unpaid tickets and things, and so he's been working at that. And hopefully he'll have all of that in order. He's a hardworking guy. He works quite well. He's listening and moving and clean. The court will resolve this with settlement fines and costs.
All right. So where do you work, Ian?
I'll work for local 149, and then I'll just pick up the second shift. So I've been trying to get somewhere ready to help my family out. So
Okay. And so how did you get here today?
it's dropped
Who dropped you off?
my friend from work. I'm gonna catch up with her back home.
And so you're sure you didn't drive? You might as well just be honest.
Okay, yes, I'll try.
That's what I thought. Sir, do you want to get your license back, or do you want to keep giving your money to courts?
I want to get my license back.
Right, then stop driving. As inconvenient as it may be to not drive. You're going to have to just suck it up and not drive so you can get your license back. Your license is suspended through a course of actions that you've taken or not taken, whatever it may be, sir. So if you don't want to continue to give your money to courts, don't continue to drive. It's that simple. And then you have to figure it out for yourself how you're going to get back and forth to work. I'm sure there are people that live near you, sir, that could offer you rides, or you can get a ride to a rideshare location. How do you expect you're going to get your car back home? Because you will not be driving out of this parking lot.
Call somebody and have them drive me in a car.
Well, you have to call two somebodies because somebody will have to drive your car and somebody will have to come pick you up. Unless somebody's going to come take an Uber to come take you in your car home. Why are you suspended, sir?
I believe. So my license, I should have changed the address on my license. So I wasn't receiving my mail. And even my family sometimes, like up in off. So I wasn't able to get my mail. And I really need to get on this court, to be honest. It was just good. It was recently, it was recently good about it up on the my license was suspended and I paid was still at work. And then getting back in a career and then happening, to be honest.
Right. So here's how that happens, sir. If you get a ticket and you don't pay it, they can suspend your license. If you get a ticket while you're suspended, it's going to resuspend your license. So to prevent all of that from happening, stop driving. Because every time you get a moving violation or something abstracts onto your driving record while you're suspended, you're getting resuspended. So stop doing that and you won't continue to get suspended. So you can be guaranteed you're going to be suspended again. And not only that, but even when you're suspended, you continue to drive. And when you don't pay your fines and costs. So have you paid your matters in Allen Park?
Allen Park, I believe it's $1,300. That was another reason why I got the second job. Really to pay off everything.
Right. And I can appreciate that, sir. So in the meantime, stop driving because you're going to continue to be working to pay off these tickets and you're going to continue to drive. And then it's going to be this big downward cycle that you're not going to get out of. So stop driving. That will stop that cycle from continuing. Stop driving. So, where are did you pay Livonia, St. Clair Shores, Romulus?
I think I just got all of those cleared up. And so I believe I went to court for that last week or something. With volume, I went to court to make a plan with them. I didn't buy no more payment plan.
Okay.
Picked up the second job.
Right.
I understand, I'm supposed to drive. Obviously, I'll just have one of my siblings or my parent drive on car and pick me up from where. That's the bus.
Well, sir, paying your family members to drive you to and from work, right, would probably be less expensive than all the money you're paying to the courts. Right? So, I'm sure, sir, you can pay somebody money to drive you back and forth to work if you can't find somebody that lives in your vicinity from work. I find that difficult to believe. You can't find anybody that lives within your vicinity. So, the court's going to order a $400 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50. That's a total of $725. Is there a warrant fee and a clearance fee? $100 warrant fee?
Yeah, no clearance.
All right, $100 warrant fee. So the total is $825. You did post a bond. Nope. That bond was forfeited. All right. So how much can you pay per month and what date of the month works best? Keeping in mind that you have other courts you're paying.
Okay. I start paying on Wednesday of the next month. That's the first.
You want to start October 1st? Does that work best for you?
Yes.
All right. And how much can you pay beginning October 1st?
I'll be $100 per month. I'm gonna be able to pay more, but for a fact, I'll be able to pay $100 minimum.
Okay. And you can do $100 per month,
Yes.
even with all the other courts you have to pay?
Yes.
Okay. So what I'm going to do, sir, is I'm going to give you a gift. I'm going to indicate that the first $100 is going to be applicable to your warrant fee. Okay. So that if at some point you end up becoming able to drive, that won't prevent you from doing so. Okay. All right. You are not to drive out of this parking lot because we will be watching and you will be pulled over and you will be arrested.
Okay.
So you have a lot going for you. Don't do that. Make sure you make an arrangement so you can have somebody pick you and your car up. If for some reason somebody can't pick up your car, then just make sure you're notifying the police department so they don't have it towed and let them know that somebody will be back tomorrow. That somebody better not be you. Am I clear? All right. Okay. Thank you. Have a good day. You can stop at the window and get information about paying online if you'd like. Okay. Thank you.
Thank you.
Do we have Miss Beaver's file? Did you speak to Miss Beaver? And
I have, but I was been waiting for the prosecutor to find out doing something.
Okay.
I have spoken with her, but I'm not.
Okay.
Don't look yet.
Okay. Is Jabari back in here?
I don't know.
Is Allie there? Oh, I saw her. No.
She was on her way down the hall there. There she is.
Alrighty. Okay, Miss Beaver, if you can please hit unmute. I know there's not that much distance from the attorney's office that Mr. Boy was just in.
That was attorney speak.
Yeah, be right in attorney speak.
Marcy. Kiss.
Okay, so Mr. DeBoy,
I told you.
can somebody please go grab Mr. DeBoy? I'm not really trying to be a pain, but it's been on here for 6 hours.
That's okay.
As Bobby clarified, it was attorney speak. I'll be right in. So there's not much distance between the office and over here, but all right, let's go on the record in the matter of the state of Michigan versus Michelle Beaver, 251296. Counsel, your appearance, please.
Your Honor, Dale LeBoy here on behalf of Michelle Beaver joins us via Zoom. Ms. Beaver, can you hear us? Would you state your name, please, sir?
Ma'am, your name for the record, please.
Michelle Ray Beaver.
Okay. And today is the date scheduled for the adjourned for the pretrial in council.
Yes, Your Honor. I've had an opportunity to discuss this matter with Ms. Beaver as well as with the assistant Lee County prosecutor today. My client is prepared to offer guilty plea to count, I believe it's count 1, operating while visibly impaired. Count 2, I believe, would be dismissed.
All right, ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. And you heard the plea that was placed on the record, correct?
That's correct.
As to the charge of count 1, how do you plead? Operating while visibly impaired by alcohol.
Guilty.
You've gone over your advice of rights with your attorney, correct?
That's correct.
And you understand all of those rights.
Yes, I do.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, I do.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, I do.
Knowing all that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
All right, and counsel, if you can please order your client.
Yes, Your Honor. You recall being in the city of, I believe, Wyandotte on the 3rd of September of this year?
You speaking with me?
Yes, I am. You recall being in the city of Wyandotte on the 3rd of September?
Yes.
And at that time, you were driving a car, is that correct? Can you hear me?
Correct.
And prior to driving that car, you had something to drink, is that correct?
Yes.
And can you describe for the court, if you recall, what you had to drink?
Top off vodka.
And after having consumed that, you believe that visibly impaired their ability to drive?
Yes.
You performed some tests at the Wyandotte Police Department that night, is that correct?
Yes.
And it was determined your blood alcohol level was above the legal limit. You admit that?
Yes.
I believe the result in the report is 0.286.
Yes.
Do you dispute the test result that came in at 0.286? So do you dispute that the result was over the legal limit? That was at the result said it was at 0.286. Do you dispute that?
No.
Very satisfied.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge, dismiss count 2 per the plea agreement. And the court will order a bond and conditions are continued. And you will speak with probation. I believe that I don't know if they're going to log in now or not, but they may give you a different date given how long you've been on screen. So we will see you back at sentencing. And thank you very much for your patience, ma'am.
Thank you, ma'am.
Record in the matter of the state of Michigan versus Erica Bond, 251196. Ms. Bond is not in here. Okay, we'll grab her in a minute. Is James King in here?
Yeah.
Okay. Let's go on the record in the matter of the state of Michigan versus James King, 251179.
Ready, Your Honor. Neil Wood here on behalf of James King III. State your name, sir.
James King III.
Thank you.
Oh, the third. Okay. We don't have that information. Okay. And I apologize for your delay today, sir. I know you've been here quite a while. Mr. DuBois clearly has been pulled in a lot of directions, which I'm sure you've been able to see all throughout the day. So I do appreciate your patience. Today is the date scheduled for the arraignment and pretrial, and counsel as to the arraignment.
That waives formal reading, stands muted to the charges.
The court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment as to the pretrial, counsel.
Yes, my client, after discussions with the Wayne County Assistant Prosecutor and discussions with my client prepared to offer the guilty plea to the added count of operating while impaired, being intoxicated, that would be first offense. He's also pleading guilty to counts 3, driving while license suspended, and count 4, having open intoxicants in a motor vehicle. The original counts 1 and 2 would be dismissed.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the amended charge of operating while intoxicated first offense, how do you plead?
Guilty, Your Honor.
As to count 3, driving while license suspended, how do you plead?
Guilty.
As to count 4, open intoxicants in a motor vehicle, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes.
You also understand, sir, by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And any immigration issues?
No.
Counsel, if you can please forward to your client.
Yes, Your Honor, I will. Mr. King, you recall being in the city of Wyandotte, I believe, on August 8th of this year?
Yes, sir.
And at that time, you were operating a vehicle on a public road.
Yes, sir.
And prior to operating that motor vehicle, you had something to drink.
Yes, sir.
What amount and what was it?
Some Budweisers and then tequila.
And you had an interaction with the Wyandotte police officer, is that correct?
Yes, sir.
And ultimately, he, after investigation, brought you to the station, and you used a machine, something that's called an intoxilizer, to determine your blood alcohol level. You recall that?
Yes, sir.
And you recall what the result of that was?
0.182.
I believe that's correct. You do have any reason to dispute that number? No. Also, during this time period, it was determined that your driver's license was not valid, was in fact suspended, correct?
Yes, sir.
And furthermore, during the investigation, they found some open cans of beer in your car.
Yes, sir.
Your Honor, I'm satisfied with that.
All right, counsel, just for purpose of the record, the intoxilizer results were 0.178, 0.175. The PBT was a 0.182, yes?
Yeah.
All right. The court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge and the other charges, the two counts 3 and 4. And we'll dismiss counts 1 and 2 per the plea agreement. And as to bond counsel.
Yes, sir. My client posted cash bond. We asked the court to continue that at one time.
No.
Asked the court to just continue the cash bond. He showed up here when he's supposed to. I don't think he has any history of not showing up when he's supposed to. He is gainfully employed. I'd like to maintain that employment. In this case, cash bond would be adequate.
All right. And where do you work, sir?
I work at Quanzo in Taylor, but tomorrow I have an interview for Steel Tool. I can't remember the last part, but it's a better paying job and it's closer to home.
Okay. And what time is that interview?
3:00.
Okay. So, and the reason I ask is because given your level and given that this is your second offense, right, and you already know at what level you feel intoxicated, the court's inclined to order alcohol tether. So I just wanted to kind of see when that was, because you'll have to go down to get that alcohol tether prior to
I also have work tomorrow too, like my normal job.
Okay. So what I'm going to do, sir, if you were to test right now, what is in your system?
Should be nothing.
Okay. If something was in there, what would it be?
Marijuana, but I haven't smoked in a minute. But I smoked a lot prior, so I don't know how long it would take for it to get out of my system.
Okay. So the court's going to order you not to possess or consume any alcohol or drugs as prescribed. Are you out on bond in any other jurisdiction?
No, you're
Are you on probation or parole anywhere? That's right. And what are you on probation for?
When I crashed my truck and left it, I can't remember what the charge is called, but
Oh, that's right. Failed to, I think it wasn't it reduced to failed to report?
I think so.
Yes, that's right. Okay. So the court's going to continue your cash bond. I'm going to order you to have an alcohol tether through the Wayne County Jail. You can do it on a walk-in basis, so you don't have to be taken into custody. And I'll give you until Monday.
Can I go on the weekend?
I just put by Monday, so you can communicate with probation as to whether or not, I don't know if they have their tether unit that does it on the weekend. I'm not sure. It changes hourly. I don't know. And they will test you when you get down there. So if there's anything in your system, as far as alcohol goes, then they will take you into custody. So, all right. Please stop over probation. You're going to get a copy of your bond conditions and some dates to return as well. Okay.
Thank you.
All right. Thank you. Well, you'll get your sentencing date from there as well. All right.
Have a nice day.
You as well. Is Ms. Bond in here yet? No. Okay. Well,
Elizabeth, that's she in Sunday, right?
No,
Oh,
she's in here. They're both
Elizabeth.
Elizabeth. One's this is DeSanto, that's Mullins. They do kind of look a little bit like.
But her name is Elizabeth, I remember.
Yep.
How is she?
How is she?
Yeah. Give or take.
She's good. You know, I mean, she's can be kind of strict, but you know, she's fair.
all right. So let's go on the record in the matter of the state of Michigan versus Stephanie Ward, 251367.
good afternoon, our neighbor boy here. We have Stephanie Ward, joint in Zoom, in jail. Ms. Ward, can you hear? Please state your name.
Stephanie Cesaria Ward.
All right, thank you. And so today, counsel, as your client is in custody, is the arraignment. And so ask the arraignment.
Yes, my client waives formal reading, stands mute, charge.
Court waive the formal reading, enter plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on October 2nd at 9:15 a.m. And counsel asked to bond.
Yes, Your Honor, it's my understanding that the family member's already posted a cash bond of $500. In addition to that, I'm advised that she has taken a PBT within the last 20 minutes and it registered 00. She indicated to me she never failed to appear. She isn't from court hearing. She being employed with the advanced estimate. She's also a student at Baker College. She is a long-time resident in Salmgate. She supports your child. She's setting risk of flight. And that's court to continue that cash bond of $500.
All right. And so, ma'am, are you currently on probation or parole anywhere?
Yes, Southgate, Michigan.
Okay. And is that, so that's probation. And what are you on probation for?
The same thing.
And how long have you been on probation?
I actually supposed to been getting off this month. My last appointment with her is for this month of the 30th.
That's interesting. Because I'm showing a conviction of April of 25 for 18 months probation. And so half of that is 9 months. And we are definitely not at the 9-month part yet.
Yeah, she was allowing me to go early due to the fact that I finished up with community service, pretty much all the stuff that they wanted me to do. And plus, I'm also in school.
Okay, well, it appears perhaps some of the conditions that you were given for probation didn't really work. If you were to test right now, ma'am, what is in your system?
Nothing. I don't do no marijuana. I don't do drugs at all.
Okay. And where is it you work?
Advanced Heart and Vascular Care in Lincoln Park. I work under cardiology.
Okay. And so, how long have you been there, ma'am?
I've been there for over a year, almost 2 years.
Okay. All right. Well, here's what the court's going to do. The court's going to, two things. Number one, the court's going to take into account that you're currently on probation, and you've only been on probation for 5 months, for the exact same charges you're currently in custody for, and that, the levels were of sufficient basis that this court finds based upon both the current levels that are alleged as well as your current matter you're on probation for, that an alcohol tether to the Wayne County Jail is appropriate. The court's also going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs that are not prescribed. And so, ma'am, you will not be released without having an alcohol tether. So you're going to take the ride downtown and then they will fix you with a tether.
Okay.
All right? And we'll see you
Yes.
back October 2nd. Thank you. Have a good day.
Thank you.
Thank you. Off the record.